All right, how does the United States commitment to the rule of law appeal to other peoples? How would you explain the meaning of the rule of law? And how do America's founding documents express the nation's commitment to the rule of law? And when you're ready, you may begin.
In 1788, James Madison defined rule of law in Federalist 51. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. Rule of law is essential to maintaining a democracy, or justice and equality within a republic. As such, it is promoted within the Supremacy Clause, Article 6, Section 2, which makes the Constitution the supreme law of the land, and binds all government authorities, as well as their constituents, to an obligation to support the Constitution.
Rule of law ensures legal equality between the highest government officials and individuals, where the rights of the few are balanced against those of the many. The philosophy is promoted within the introduction of the Declaration of Independence, which asserts that governments are instituted among men, deriving their just powers from the consent of the governed. This affirms that every individual in a society is held accountable under the same legal principles.
In the United States, the president is held under the same restrictions as a normal citizen. The government is obliged to control itself, and it does so within the impeachment and removal processes delineated in Article 2, Section 4 of the Constitution. This is reflected with the Supreme Court case U.S. v. Nixon over the recorded conversations in the Oval Office, known as the Watergate scandal.
The Magna Carta, written in 1215, was one of the first documents expressing the principle of rule of law. It asserted that the king was equal under the law, establishing uniformity between the barons and nobility. This principle was reiterated in documents such as the Mayflower Compact in 1620 and the English Petition of Rights in 1628. In colonial America, the Virginia Declaration of Rights states, "All men are by nature equally free and independent." The idea of rule of law was reinforced by listing the rights and limitations written in the Constitution, further signifying America's commitment to philosophy.
Coining a contagion of sovereignty, Harvard professor David Armitage recognizes that rule of law establishes a constancy that appeals to foreign countries. The ideal represented in the founding documents of America's history is often replicated by revolutionaries seeking justice for their own country. The Declaration of Independence states, "All men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness."
The decree of the French Revolution, liberty, equality, fraternity, echoes the Declaration in its pursuit for freedom. The global effect of the Declaration of Independence has represented the readiness of foreign countries to promote the ideas of equality under the law. The 14th Amendment of the U.S. Constitution states, "Nor shall any state deprive any person of life, liberty, or property without due process of law, nor to deny any person within its jurisdiction the equal protection of its laws." The simple distinction of all persons instead of citizens furthers America's commitment to rule of law, which is applicable to other countries.
Once again, applying to all persons, Article 3 of the Universal Declaration of Human Rights affirms that everyone has the right to life, liberty, and security of person. In Syria, where President Bashar al-Assad has repeatedly slaughtered hundreds of his people, the rule of law is a bleak hope. In Afghanistan, an estimated 80% of all criminal and civil cases are resolved outside the legal system through forms called jirgas, a form of community mediation that leaves tribal customs to supersede rule of law.
These forms typically fail to acknowledge individual rights and tend to exclude women from participating, undermining the rule of law. You must first enable the government to control the governed, but an inability to achieve control leads to an inability to establish rule of law. Constitutionalism and rule of law are the cornerstones that reflect our country's commitment to an orderly and civil society in which all are bound by the rules, principles, and values of our Constitution as the supreme law of the land. Thank you.
Is the idea of upholding the rule of law more of a classical Republican ideal or a natural rights ideal, and why?
I would say rule of law is more of a classical Republican ideal because understanding the concept of enlightened self-interest, it's the idea of promoting the common good by also, and then promoting individual interests. So it's almost a win-win situation.
I think rule of law also plays really well into natural rights philosophy, so I'm going to disagree a little bit with my colleague here, because rule of law is basically the idea that no one's rights are subservient to anyone else's rights. So for the example that we use of the United States, any ordinary citizen's right is not any less valued than the President of the United States' rights of the same manner, or comparable rights, I guess.
You raised, you mentioned, I think, was it the Indian Jirgas, is that correct?
The Afghanistan.
Afghanistan. Why do you suppose that over the last, say, 30 or 40 years, we've had trouble replicating our system of governments in other countries, particularly non-Western nations, such as Afghanistan or Syria, Egypt? Why are we having trouble translating, I guess, our system to some other cultures?
I think there's two issues there. First of all, the issue is that in a lot of these war-torn countries, there is an intense or immense levels of poverty because they have suffered for so long from an infrastructure of government that is not created to serve the people, but is more created to serve the dictator that's in charge. So that's the first issue, is that people there are struggling to live day to day, which makes it difficult for them to focus on other issues at hand. The second issue is that Westernization is often perceived as a bad thing because most people, specifically those that are facing poverty, don't like the idea of Americans coming into their country and trying to tell them how to create a certain system of government. So it builds up a certain amount of resentment towards the United States.
The history of these areas, such as the Middle East, have been tribal in custom as well as nomadic. So imposing a democratic form of government wouldn't necessarily fit within their history, as they do move around and intermingle, and boxing them off in a single country would include cutting off ties within several different little communities that do exist within each other.
You guys represent the U.S. Constitution in this governmental form as really being founded on the rule of law. The judiciary is built into the Constitution. It's one of our branches of government. Their job is to interpret the Constitution, and often you'll have circuit splits. You'll have courts interpreting the same thing in different ways. Would you then say that a judicial decree is a rule of law?
I think judicial decrees can help implement rule of law. So rule of law is kind of going to be something that's very dynamic because because we have rule of law that's being policed in a sense by the Constitution, and because there are so many different manners of interpreting the Constitution, then of course regionally, I guess you could argue that rule of law is being applied in some instances differently than in others. But that's the case, or that's the purpose of having specifically the Supreme Court, or a national judiciary, which can kind of lay an overarching foundation, an overarching interpretation of the Constitution that then serves as the basis or as the guideline for the smaller facets of our federalist system.
Does the lack of a right to counsel in civil lawsuits create a barrier at all to the rule of law within our own country?
Can you repeat the question, please?
Sure. Does I guess lay some framework. In a criminal context, under, I think, Gideon v. Wainwright, you have the right to an attorney to represent you, but you don't in a civil proceeding. Do you believe, or do you think that can hinder the application of the rule of law within our states, or is everyone adequately protected without needing a lawyer?
Because of cases like that where they're so minor that attorney isn't deemed necessary, the rule of law is still upheld because it applies to everyone. It doesn't apply to just one minority or one group of people. So having it equal over the entire population makes it deemed a rule of law.
I think that everyone ought to have the right to legal counsel, and regardless of whether it's a civil case or a criminal case. That being said, I'm going to agree with my colleague that because it's not a right that is applied to certain individuals but denied to others, then rule of law is still upheld in this blanket lack of a right to legal counsel in civil cases.
Is public safety a good reason or sound reasoning for limiting constitutional rights?
As seen in Section 1, Article 9, the, I guess, denial of habeas corpus within times of rebellion and invasion to protect public safety within the Constitution does give the right for the government to supersede the rule of law in times when it's truly deemed necessary.
As seen with the Japanese internment, therefore their trial by jury, that right was limited, and for the protection of the U.S. after the bombing of Pearl Harbor.
Jury?
Their,
Did I even mishear you?
their
No, you misspoke. Go ahead.
the right to a trial was limited or restricted
Why?
because of the bombing
What bombing where?
at Pearl Harbor.
So what does that have to do with the trial?
Because they believed that there were insiders in the U.S. plotting against us, working for the Japanese.
Do they do it? So what? Why was what's your point in saying that? What happened to the Japanese?
The-
What was really taken away from them?
Everything?
Okay. So let's talk about that. There was no due process before we even get to the trial. There was nothing happened. They had a court order that they had to report at certain stations by this with all of everything they could carry with them, and then they were taken. There was no due process for it at all. So before we even get to a trial by jury of your peers, we got to talk about the idea that the due process never existed in the first place, with the trial by jury still being part of that due process. You need to look at Korematsu, and if you're going to use it, you need to be able to understand it and know it better. Okay? We'll go ahead and stop there. Go ahead and give feedback, judges.
Again, excellent.